Hi, this is Rick Frederick, reviewing the case of Lyles v. U.S., a D.C. Circuit Court case from 1957. What is this case about? The case is about whether juries should be told what happens to people found not guilty by reason of insanity. So in this case, Lyles was indicted for robbery and larceny. In 1955, early 1955, he was found not competent to stand trial and committed to St. Elizabeth's. And then later in 1955, he was declared competent and ordered to trial. So they had the trial. During instructions to the jury, the trial judge informed the jury that if Lyles were found not guilty by reason of insanity, he would be committed to St. Elizabeth's until he was deemed safe to be released, and that would be the end of it. The judge then said to the jury that a doctor had previously determined that Lyles had no mental disorder. And then the jury returned a verdict of guilty. What was the issue? There were a number of appeals here, but the one for this case that we're interested in, where the insanity defense is asserted, what, if anything, should the court instruct the jury about the consequences of a verdict of not guilty by reason of insanity? Excuse me. And the answer is the court should inform the jury that if the defendant is found not guilty by reason of insanity, he would be confined until he had recovered his sanity. And the D.C. Circuit Court said this instruction should be given unless the record reflects a waiver, an affirmative waiver on the part of the defendant who says, I don't want them to know that. Why they don't want to know it, I'm not sure what the reason would be, but we can probably think of some. The appeals court reasoned that it was common knowledge of what happened to people for a verdict of guilty and a verdict of not guilty, but that it wasn't common knowledge what would happen to a person who was acquitted by reason of insanity. And so their position is the jury had a right to know the meaning of the verdict, what would happen. With respect to the judge making this comment about the defendant's competency to stand trial and a doctor saying he had no mental disorder, they said the judge made a mistake, but that it was harmless error. So there was no reversal on that basis. The jury also had no reason to be interested in when or whether the defendant would ever be released or what happens at a mental hospital, even though they had the right to know what happens that this person's committed until they're deemed no longer dangerous. They didn't have a right to know more than that. So that is Lyles. Thank you very much.